Should you refuse a breathalyzer in Canada? Heck no, you shouldn't. It's a criminal offense in Canada to refuse to comply with a breath alcohol test, a saliva test for drugs, a field sobriety test, a drug recognition evaluation test, a blood test, as long as the officers lawfully demanded it. And you cannot determine when you're dealing with the police officer whether that demand is lawful. That's just not possible for you because the demands have all sorts of nuanced components depending on what type of demand is made and what the officer believes. And because you're not a mind reader, you don't actually know what the officer believes or whether that belief is necessary to justify the type of demand that the officer is given. So absolutely do not ever refuse to comply with a demand. You should not take it upon yourself to determine the lawfulness of that demand. While you could end up charged with being over the limit if you are in fact over the limit, or charged with impaired driving, or charged with being over the drug limits on the basis of the information that you provide through your bodily samples or through your performance of the tests, you can always argue in court that those tests were unlawfully administered or demanded of you, and as a result of that, the evidence should be excluded. And that is better than trying to say that you didn't have to comply with a demand if the demand was lawful, because refusing to comply with the demand has the worst possible penalty as a mandatory minimum for DUI. It's a $2,000 fine, a 1-year driving prohibition, and an automatic criminal record. So do not refuse to comply with any demand for any type of sobriety testing in Canada, because you can never be sure that that is not a lawful demand.